Thanks very much. I just have some quick questions to do with the best financial interest duty. The super fund CBUS spent $370,000 on a birthday party for itself. It hired the Regent Theatre in Melbourne and invited a number of its best friends, including union officials, politicians and the like. Would that pass the best financial interest duty?
I'll ask Ms Cole to answer that, Senator, and talk to you about how we view the BFIT.
Yes, Margaret Cole, Deputy Chair of APRA. Well, Senator, that indeed is a matter that we have under inquiry. As you will know from announcements we have made recently, we placed some licence conditions on CBUS last year, requiring them to have an independent third party look at certain issues. Those issues went to the subject of fitness and propriety of directors and also certain expenditure payments. That matter was reported on by Deloitte, and the consequence of that has been that we have now entered into a court enforceable undertaking with CBUS regarding various work that has to be done by them to improve operational risk matters and matters such as controls around expenditure. Also, and that CEU was published, I think, a week or so ago, also they have produced a remediation plan for the recommendations of the Deloitte report, and that has been accepted by us and announced publicly. Now, also as part of the matters that we were looking into, we took a somewhat unusual step of announcing that we had commenced an investigation. That's an enforcement investigation under our formal enforcement powers. Because of that, Senator, and because that is current, I'm going to say very little about that, other than its investigation into CBUS's approach to expenditure management following concerns that have been identified in the experts' report. And I think you'll be aware, Senator, and indeed Deloitte's appeared before you recently, of the fact that I may be paraphrasing Deloitte's words, but they found certainly insufficient evidence of systems, controls and procedures around expenditure management of the sample areas they looked at.
Okay.
So I think the question you're asking is exactly what we're testing in the investigation that we're currently carrying out.
Is the birthday party part of that investigation?
Aspects of expenditure wider than what was simply looked at in the Deloitte's report are subject to that investigation. I look to my legal colleague to the left to confirm whether what I said was accurate.
What do you know about the birthday party?
So the CBUS's approach to expenditure management generally is under investigation currently. I don't think it would be appropriate for us to comment further because of any prejudice to ongoing enforcement activity. So
I imagine more generally then in your role as a regulator you would be proposing to publish something at the end of this investigation which is a deterrent to others?
Well, Senator, I think the whole purpose of enforcement cases, if brought following an investigation that substantiates evidence to bring them, is to send deterrent messages. You're completely right. It's to deter in the specific case, and it is to send a wider deterrent message. But the thing I have to say is this is the commencement of an investigation. Obviously, we have to go through the process,
I understand,
gather the evidence, take legal advice, make decisions, and if appropriate, and there is a case to be brought, advance that case. The fact that we have put into the public domain as part of that package of measures with CBUS that we have commenced an investigation is something that we thought we should do in the interests of transparency and the public interest. It won't be in every case that we announce an investigation because actually that's just the commencement of a process. But because we were going to talk publicly about other CBUS matters, we concluded that it was correct and transparent to put that into the public domain. Where we do that, Senator, it's clearly the case that we either arrive at a moment where we bring a case or for whatever reason we decide there's insufficient evidence to bring a case. So what happens in relation to that case will inevitably be a matter in the public domain.
Yeah. Look, I really appreciate the work that you're doing at APRA. I think it's very important, high-profile work because there is so much money at stake here and there is a potential for great malfeasance. But I would say, and this will lead me to a question, that I do think a lot of this work has been developed because of the 9 newspapers' investigations into the CFMEU. That has generated a lot of this work because it pushed it into the public domain in a way which was irresistible. So I guess my question is, are there other funds and are there more systemic approaches to investigating the overall expenditure on inappropriate things like birthday parties and junkets and the like?
Well, we have published a significant amount of expenditure data now pursuant to the transparency push that we've been heralding for a while. And in the context of that, we have given messaging and speeches about how we are going to push into certain areas, how we're essentially going to select from a whole massive amount of data cases that we think deserve or warrant following up because they look unusual or on the face of it, how can this be in the best financial interest of members?
Okay.
I will go back on your starting premise, Senator. APRA has been building an enforcement capability for some time now, a time that predates by a significant time the CFMEU revelations.
Good.
So that capability, part of it is represented in this room now. It was part of a deliberate determination by APRA a couple of years ago that we had to have the capability ourselves to pursue some enforcement cases, even though the primary focus of our business is a prudential regulatory supervision. So you can track back to when we started to make those developments of that team.
Good.
And I am very pleased to say I think we have a highly effective enforcement capability now, although not a huge one.
That's good. Just finally... yes,
because I think it's an important point that Ms Coles ended on. I mean, you will form your own views on the catalyst for action. What I want to make very clear is we have a systematic approach on how we view things. We have a law to administer that is very clear, and we've got a posture that where supervision is not working in the way that we need it to work, we will escalate up the toolkit and we will use all mechanisms at our disposal. And that is regardless of what's printed in the papers or anything else. That's our own view.
I can see that, and that's very much welcome. Look, just finally, I'm conscious of time. I have to say I have been critical of APRA for facilitating the changes to the trust deeds a few years ago. I'm wondering whether, on reflection, you've considered whether that was a good thing to do in light of the best interest duty and in light of the best financial interest test. Because ultimately, the fines that are likely to be accrued by these funds, and at the moment I think there was one handed down on Friday to the Federal Court to Australian Super of $27 million, that is now going to be paid by the members. And that is because of the trust deed changes that were facilitated through the state Supreme Courts. So I just wonder, on reflection, I don't expect you to say here at St Espetal, we've completely buggered it up. But have you thought, on reflection, whether that is going to be in the best interest of members, that when big fines are coming in, that the members will pay, not the shareholders?
Senator, I think we've thought about this a great deal because it's been a debate in the public eye, actually, since quite some time. I think since the changes to the legislation were mooted in 2019, certainly since I joined APRA in July 2021, it was an issue that was being widely discussed. I suppose I'd slightly take issue with changes that APRA facilitated. I would say that APRA, with a great deal of care and with the benefit of advice, took the view that what it should do is intervene with the courts in most of the court applications to explain to the courts the importance of the issue, to explain the context, to explain APRA's mandate, to explain the best financial interest duty and to make sure that the court was aware of all those issues. The other reason for intervening is that in each of the applications to change a trustee, it wasn't a generic application. What we needed to look at is or invite the court to look at, was what was specifically intended, how specifically that would work through, what specifically was the amount that was to be built, for example, by way of a trustee risk reserve, and how that was to be governed, if you like. And we went into this process intending to assist the court and the process by pulling out all those relevant details. When you look at the issue as it was considered by the courts, they looked at the wording of the legislation. And I know, Senator, you know far more about this, the passing of the legislation, than I do. But a court interprets the intent of Parliament through the wording of the statute that is put in front of it. And the wording of the statute was quite specific as to indemnification provisions. And the court, and I think there were 15 applications, and all courts held that what was intended and put forward by way of changes to the trustee to raise fees for the purposes of building a trustee risk reserve did not infringe the wording of the provisions in the statute. Now, that's how the system is supposed to work, I think. Parliament passes legislation, courts interpret it. Our agency, with great care and thought, invited the court to consider a number of relevant matters. Those relevant matters really did go into the best financial interest duty, which had to be weighed against the possibility that a major super fund like Australian Super could be rendered insolvent by a relatively minor administrative fine. That was an issue considered by the courts. The courts weighed the balance of the best financial interest duty with the interests of members. So I feel that APRA did the right thing there. We can choose to disagree. We stand by what
just quickly, because time is short. I just wanted to check whether or not you actually did ask. Sorry, did you want to say something? Sure. What would you like to say?
If I thought Senator Bragg was remotely motivated by the best interests of superannuation members, I'd be paying attention to that.
Thanks for your political speech.
The idea that his concern about these is motivated by anything but an entirely ideological
point of order?
view.
Yeah.
You're now impugning that. You've got no idea. You're way out of your depth. You are way out of your
ideological view.
You are way out of your depth.
That is all about. That is all about.
Point of order. He's impugning.
Not being able to.
Sorry. Point of order. Point of order.
Minister.
Be quiet. Point of order.
Minister.
Yes.
If you just
disgraceful.
take a rest, and also Senator Bragg, I'll just note that uncharacteristic behaviour on your part,
sure.
but you have
he's impugning my motives.
Yeah, your point of order is that the minister attributed motives to you, and Minister, you might sort of reflect on that as I give you the call.
Thank you. Well, we all have different motives. Some of them about the public interest, some of them not. But it's a matter for other people to make a judgment about that, I suppose.
Well, look, I'm conscious of time, and I guess my only other very brief question was whether you considered whether the shareholders could make a contribution to avoid that insolvency.
That really is a policy question for Treasury, in my view.
So we just had did you listen to the answer? She just gave a very detailed answer about the legal mechanics of how the trustee works.
I did, yes, and I heard her answer. I think a long discussion about policy views is not something that the agency is able to.
I don't think that is a policy question. It's a question of operation of the law. So can we just seek some advice on that?
I have something of an answer, whether it will satisfy.
So I think we might give you the call, Ms. Cole, and see what happens. Deputy Chair.
One of the things that we did invite the courts to go into was whether the trustees who were seeking an amendment to the trustees to raise the fee raising for the risk reserve had exhausted all other possibilities of raising funds to cover such a penalty. The primary one that people looked at, actually, that pops into my mind is insurance. I can't actually remember whether anyone addressed the specific question that Senator Bragg is raising, But I do know that APRA does not consider it within its powers, and this is where the policy point the Minister made came in, to simply decide to impose a shareholder capital requirement on not-for-profit super funds. And I also observed that super funds were required to have capital in the sum of $5 million up till 2012, when that provision was repealed and replaced by APRA's own requirements in our standards to have an operational risk reserve, and now the provisions for a risk reserve to pay penalties. When that risk reserve is created, like it or not, Senator, the law says that that is no longer members' money. So fines you are talking about will not be coming out of members' money. They'll be coming out of money that's on the trustee's own balance sheet.
Thank you very much.